Hello, good morning, ladies and gentlemen. I'd like to thank all the attendees who are with us following this streaming. This is table number 6, Compare Developments of Anti-Discriminatory Law in Latin America. I'm Miguel Casillas. I'm going to be the moderator of this table. I remind you that these lectures will have simultaneous interpretation into English and Spanish. The broadcast in Spanish is through our official website and Facebook and the YouTube channels of the Supreme Court, and the English broadcast is through the website of the Constitutional Studies Center. Also, I'd like to remind you that the tools of the chat and the questions are active in the different platforms for you to ask your questions and concerns throughout this presentation. We have the pleasure of having with us extraordinary panelists about today's topic. I'm going to introduce them. First, we have Dr. Francisca Pou. She has a master and a PhD of law from Yale University. Her research is focused on constitutional reform and constitutional change, compared analysis of Mexican constitutionalism, the control of constitutionality and judiciary, with emphasis on the analysis of the relationship between institutional relationship and performance and the protection of rights, focused on anti-discriminatory law and gender issues. At present, Dr. Pou is Professor of Constitutional Law at ITAM. Thank you for being with us, Doctor. We also have with us Dr. Laura Clérico. She has a PhD in law from Yale University. Her research is focused on the study of human rights and constitutional rights, as well as equality and gender perspective. Doctor has authored many articles and books like Rights and Proportionality, Violations Due to Action, Insufficiency and Regression, Local Outlooks and Compared Inter-American Outlooks, and the Proportionality Test in Constitutional Law. At present, Dr. Clérico is researcher and professor of Constitutional Law in the degree and PhD of the School of Law of the University of Buenos Aires. Finally, we have with us Dr. Alberto Macmanus. He has a PhD in law from the University College of London. His research is focused mainly on the law on anti-discrimination, human rights law, and Latin American constitutionalism. He has authored several papers, among them The Right to Equality and Non-Discrimination, Law and Policy in Latin America, and Hard in the Theory of Contemporary Law. He's assistant professor in the Austral University of Chile. I'm going to give the floor to our first speaker to open this session. You have the floor, Dr. Pou. Hello, thank you very much. I thank the Constitutional Studies Center for organizing these events. They are quite interesting, and for inviting me, it is a pleasure to be with Laura and with Alberto. Well, the table is to talk about inter-American developments from a comparative perspective. I'll talk about a paper I wrote a long time ago that will be, well, the book is about to be published. That is a comparative law of equality beyond the inter-American system. I think it can be interesting, and this is something that I haven't presented before. The project in which I wrote this analysis is a project coordinated by Rebecca Cook. As you know, she is a professor of Toronto specialist in gender equality, about the borders of the right to gender equality, frontiers of gender equality law. This was a very well-organized project, and I learned a lot from it, and people from all around the world participated. Many of them have been in this Congress Sofia Moreau, and specialists of the North that are references for all of us, Megan Campbell, Com Okinaide, Stephanie, that is in the Congress, Jenny Boucher, specialist in the European system, and then many other extraordinary people that were less known by myself, but they wrote about things I didn't know a lot, like the developments under the Maputo Protocol in the context of the African Charter of Human Rights, or about the Arab Charter of Human Rights, or the context of the new European Social Charter of the 61 that was renewed in 96. And the one in charge of the Inter-American system was Veronica Undurra, with a very nice chapter about the Inter-American system. And in the context of this project, I wrote the chapter on conclusions. So what I had to do was to try to intertwine the trends and identify the lines of evolution. It really took me a lot of time, but it was very motivating. And in that chapter of conclusions, I talked to all the authors, and this is what I want to present today, despite we have little time. But I think it is interesting to see the Latin American developments from this overarching comparative outlook. This is what Ana Maria was looking for. I will talk about developments in terms of gender equality or discrimination, but I think it's quite interesting to project this to other problems of inequality. So what I'm trying to do is to identify some of the new frontiers of gender equality law, understanding frontiers in two senses. In a topographic sense, that is the new territories, the new spaces of the gender equality law at the comparative level, and the frontier in the sense of challenges, that is, what are the debates, the tensions, and the pending items of the agenda in gender equality. And if I have to make a summary of what I understood that were the lines of evolution, I think that we have to realize there are many things that have changed in the gender equality law from the beginning. Talking about the beginning, let's say the post-war constitutionalism, both national and international after World War II, when things were simpler in the sense that evidently these legal developments started in a world where we talked about men and women, for example. We didn't have the problem of binarism, and the basic project was to transform objects into objects, create freedom and equality where there was only subordination. During 60, 70 years, I think there's no doubt that the gender equality law has been reinforced a lot and has been benefited with this trend that is to use law more for social transformation. Law has been more important than ever, and this has characterized the legal agenda of gender equality. And I also think that we've been able to correct some of the biases that the initial law of gender equality had in favor of collectives that had more influence in their initial preparation. And they were not representative or representative enough in terms of ethnicity, race, sexual identity or orientation, etc. But it's also true that throughout this way, the gender equality law has been affected by the states. Partly, of course, states now pay tribute to the gender equality law while they try to control or reduce their impact through reserves to treaties, appointments, very careful appointments in the supervision bodies or in the courts, funding cuts, etc. So we also have to remember this has been used strategically or replaced by stakeholders that are not interested in this agenda, but rather hindering it or at least domesticate it. As we know, companies now make pinwashing plans. They depict themselves as with a careful addition, but for purposes that do not match other stakeholders' interests or ultra-religious NGOs that advance their arguments with specific human rights arguments. And the gender equality law has also been criticized. And not only by these groups that are against it, but also feminist groups, LGBT groups that have denounced the imperialist character and insufficient permeation of important perspectives, the debate of the intersectionality, etc. So these are some of the things that in the beginning of the chapter I highlight, and I also think that it's an important pool of achievements, but also an imbalance of what we have achieved in conceptual and normative vocabularies, because we've had very important developments and sophistications, and the level of the institutional and regulatory solutions that should implement many things of gender equality agenda. In the book, there's a very interesting chapter from Mariana Prado and Marta Machado about the institutional and regulatory development of the María da Peña agenda, and we see the deficits there. Legal experts focus more on words and on developments and less on the institutional design. So having said this, I'm going, please tell me about time, Miguel, but I summarize the findings of the collective discussion gathered in this book in 3 different planes: the transformation or the new scenarios at the level of basic analytical conceptual elements that we use in gender equality law, understood broadly and in an interdisciplinary manner, having experts from other areas, evolutions or new territories at the level of normative paradigms that push gender equality law, and developments at the level of normative ecosystems of gender equality, the new comparative law of gender equality and what's there. I'm going to mention 3 simple things about each one, and that's it. And with that, I've used my time. At the level of the basic conceptual pieces, that is the analytical starting points used by people who work on gender equality from many disciplinary trenches, I think that here the trend is a trend to diversification, pluralism. And there has been a huge transformation in the perception of who are the relevant subjects in the field, who are, or what are the grounds, the relevant grounds for those who approach gender equality from philosophy, and what should be the legal, relevant legal artifacts, and also the legal topics, that is, the subjects, the areas that are relevant. So irrespective of the methodological variation, in all the cases, I think there's a redirection to concepts built around hard essences. There's a rejection to binarism and dichotomies in favor of a much more nuanced, plural, and diversified scenario. Let's think about the transformation of the subject of gender equality upon the statements from the LGBTQ agenda. well, I don't need to explain this because I think you are aware of this. And this is a huge diversification and a big nuance of the subjects. So Mariam Law approached from law development and all the agenda, gender agenda of the Sustainable Development Goals of the UN. And there's also a rejection of the simplified analysis. For instance, in terms of law development, gender equality has been measured with inclusion indicators. But in light of the new developments, how are you going to measure with this small unit in inclusion of structures that we know are unfair by themselves? Well, I don't have time to explain, but clearly the trend is towards diversification. And what can we say about the philosophical analysis about anti-discriminatory law? What Sofia Moreau has done, well, the grounds of discrimination is not the only ground. We need to have a more diversified palette of the grounds of discrimination. So these are the trends. And of course, then we have new challenges, because what's the new challenge? If we think about the intersectionality agenda, it's the same. But the challenge that this poses, and I think it's correct, is that the gender category is much more difficult to learn. That is, we have to rethink then the meaning of gender in this scenario and how we can build bridges despite having something more diversified. And we then have to think about this new scenario. The gender category is a category that must continue to be a focus for us. So I think that the sophistication comes with this challenge and opens up a huge agenda. Now, at the level of normative paradigms, I'm going to skip some things because I don't have time. At the level of normative paradigms, the second scope that I study, I think that the trends are not centrifuge, but centripede. There are more agreements than ever. In general, we've gone, and this is shown if you see the evolution of human rights systems and domestic law. We have gone from a paradigm of protection. The European Charter was born with a protection of women to equal treatment, to one of inclusion. Now together we got to a fourth paradigm of structural transformation. And also there's a convergence, and we can discuss this, but I see a convergence that is important around what I call a common goal of gender equality. Ideas that seem to be unanswered, and they are, for example, the idea that equality should be material or substantive and not only formal, and then it incorporates the mandate of different treatment for different people, the idea that the contemporary equality law protects against indirect discrimination and direct discrimination or unequal treatment. Therefore, the idea that the effects and the impacts are essential elements when we have to detect inequality and not the intention. I think it's not more controversial. The idea, they are the outliers in comparative law. Equality protects you before individuals and public bodies. The idea of horizontal efficacy, the idea that equality protects us from structural inequalities and not also junctural. Equality implies to pay attention to the intersectionality and the dynamics of on our prejudice, and also the idea that inequality is a principle that can be defeated. It implies that there are certain treatments that can be justified in the light of the normative weight of other rights or legitimate objectives, and then the agreed role of proportionality in many equality analysis. And I think that's remarkable. And in the chapter, I identified 2 points with no consensus. We still have a lot of debate on this. And for me, the first focus of normative debate is the role of intersectionality, not in the perception of the inequality problems. I think this is agreed upon, but in the normative theory of equality, the design of public policies with a normative theory, because I think that there we have the debate between theories like Shreya Atay, which is theoretical of intersectionality that links intersectionality with a prioritarian theory of justice. If you take this seriously, it would change the right of equality. It has advantages, but also disadvantages, especially in societies like ours, where poverty determines the process of inequality. So if you take seriously the prioritarianist theories of justice on the basis of that mapping of an intersectionality in Latin America, poverty should be at the core. Well, that changes the anti-discriminatory law of sexual orientation, gender orientation. And the second focus, I think, is the debate on the context, the role of the context. In some classic senses, we have that debate on inequality from the 90s with multiculturalism, and there's a very strong recovery of the context that comes from the criticisms to the gender equality law for being imperialist and white and from the north. But at the same time, there's always the point if we have to put a frontier or not. What about polygamy? We have to open to this, or what type of boundaries should be set? And in the official law of gender equality and treaties, it is very interesting what I've learned by seeing the Arab Charter of Human Rights, etc. Evidently, states have used the argument of the context to benefit themselves. So the CEDAW, yes, with a reserve that says that, well, we need context. So I think that's a focus for normative debate. I'm going to finish, Miguel. At the level of what I call the interaction of the normative ecosystems of gender equality, there are many developments and achievements and also challenges. If we see this from 10,000 feet, it's impressive. First, I think finally we can put in gender equality law globally, we can put things that have not been present for the same reasons due to the asymmetries of legal knowledge. What comes from African developments under the African Charter, the Farida Banda chapter, is quite interesting. Simply putting on the map things that weren't there. And the comparative law of gender equality can learn a lot from this. And number two, making exercises of more sophisticated exercises of horizontal and vertical comparativism. Horizontal comparativism, what I was saying, I don't know, the European Charter, the European Social Charter, it was renewed and a new protocol was created. It has a collective complaints system in terms of equality, not in terms of social rights, but also including the anti-discriminatory agenda. That is very interesting. We have an example of a development that we don't have in other systems, not even in the Inter-American system that has innovated many times and from which you can learn. The African developments about economic violence are very interesting. For us in Latin America, we are interested in an agenda that includes economic violence and status inequality and the Maputo Protocol are quite interesting. And something quite interesting as well in several chapters is to compare, for example, well, Alberto already knows this is something I study. What would be the difference, like with the desk committee, that basically their work are social rights, but they have incorporated the gender equality agenda based on the case law of the CEDAW committee. But what happens is that what has been incorporated are the big issues of women that have been developed by the CEDAW committee, that is work, violence, and reproductive rights. But what's the difference if we start from equality? Maybe the CEDAW committee that tries to open up to a wider vision that includes social rights. So what's the difference to start from one place or the other, and what type of different interactions can be established when you are aware of this? Or else, in this horizontal comparison, be aware of or taking the path of the Inter-American Court. This path is, now we have Article 26, but has always been the path of the interdependence, indivisibility. This is another way of joining the social rights agenda with the equality agenda. In the chapter written by Veronica Unduraga about the Inter-American system, it adopts this perspective, how the Inter-American Court has combined these two topics through their traditional doctrines and now by the use of Article 26. And of course, there are many possibilities of vertical comparison, because evidently we do not only have these gender equality ecosystems, but also think that in open constitutionalism in Latin America, we have all of them. This is used in connection with constitutional law. And you have to understand, and the discussion was very fruitful in this regard, partly you can say that the developments of the Inter-American Court are verbally so innovative and powerful in the bottom, because what the Inter-American Court doesn't want their judgments to be fulfilled, but they know they will be incorporated by national courts. So the understanding of this principle is very different to the principle of subsidiarity. And that's why it's so bold in terms of doctrine developments that the European Court couldn't dare to do, because they understand subsidiarity and the respect to the democratic dynamics is different, because the contexts are different. So at this level of interaction of normative ecosystems we are experiencing is to what extent we have abandoned a description of the gender equality system at the international level. It's status-centric. Here you said this is the universal system, the Inter-American system, and we approached the description from a paradigm that was based on the states. Now, the gender equality law has been appropriated by the actors. Luckily, the states have subscribed the Arab Charter, the CEDAW, many things that I think allow you to approach the description of the normative ecosystems from a totally new perspective. Yes, the states are still fighting for the vision of their vision of the system, but we have the transnational and national actors that use the myriad resources differently. So it's another way to approach the description of what's happening. And the committees themselves are aware and not of what they do. And they have a dialogue amongst them that is very far from what the states thought when they established the CEDAW committee or the Belém do Pará mechanism or the human rights committees. Well, I think my time is up. This is not about the inter-American system. And I think this is interesting. Thinking about the inter-American system and what's happening, that is actually global, beyond the debates we've always had in dialogue with the developments of the UN or the North, and taking this horizontal perspective of the South, everything combined. Thank you.
Thank you so much, Chisca, for this perspective. I will now give the floor to Dr. Alberto Coddou, who will also tell us and talk to us for 20-25 minutes. Alberto, you have the floor. Thank you so much, Miguel, and thanks to all the persons that work in the Supreme Court of Mexico. It is a great honor for me to be part of this conference and with such distinguished personalities with big names. So it's a great honor to be here with you. And also because with the pandemic and digitization, I believe that the resources and the content produced by the Supreme Court is really impressive. I take it with my courses, with my students, we're constantly sharing the videos and materials, and I believe it is a very important effort you do. We who speak about inter-jurisdictional dialogue, well, here you have a court that is offering all its content freely. So it is, I feel really proud to be here. And for all the audience, the students, and the public in general. What I will do now is to develop the basis of what I consider an anti-discriminatory law. And what I'm going to do is a brief introduction to what I believe constitute the basis for anti-discrimination law in Latin America. And before giving a description of legal phenomena common to the different jurisdictions, I will maintain that in Latin America, there are bases to develop an anti-discrimination law with its own characteristics that will enable the configuration of emancipatory promises, which are effectively carried out by different institutional processes. Therefore, the basis I will set forward here have a partially descriptive component that assumes that in our materials, in our legal materials and our conception of the legal practice, especially the case law or administrative practice, includes some elements that allow that this now recently born anti-discrimination law to become a revolutionary promise and plausible at the same time, and some time of a non-reformist reform about which we heard from Andre Gors, for example, in the 70s. The main motivation of this work lies in the fact of the need of reflecting on the need of the large amount of anti-discrimination laws pronounced in Latin America by different types of governments. In Argentina, for example, Menem supported a big reform to the anti-discrimination law in Argentina as a way of attaining the approval from a package of economic reforms that were of privatizing nature that will place the Argentinian market into the open to the international cases. In Chile, someone who was part of the Forbes magazine and came in with the concept of a coalition and joined the Pinochet dictatorship is the one who enacted this anti-discrimination law, sexual protection for the first time included in Chilean laws. And in the case of Bolivia, the law against discrimination and racism was also part of one of the reforms promised by the coalition of the socialism movement led by Evo Morales. And this phenomenon has its correlation in Europe. which consolidation is expressed in the level of sophistication of the directives of the European Union on equality, not only including these protected categories, but force the members to establish administrative points to fight discrimination, demanding reports in the whole continent. The governments from different political colors develop with more or less enthusiasm their obligation of implementing a European anti-discrimination law. However, the case of Europe also has its contrasts, and perhaps here is where the answer lies to our original concern. The European anti-discrimination law has been developed, consolidated, and perfected at the same time that the social agenda has become stagnated without having important progress in collective rights, such a way that the possibility of a European consensus, quote unquote, in the area of social rights is ever more difficult in a context of austerity and lack of international solidarity and reluctance to extraterritorial assistance. So, what does it mean that governments from different political orientations defend the idea that equality and non-discrimination is a fundamental right, and at the same time they don't get national or transnational consensus in this area? How progressive can be the anti-discrimination law in this context? It is a problem of displacement, whether policies of identity displace the priority that equality policies used to have, or economic redistribution, or perhaps a questioning from the market. Anti-discriminatory law seems to be concerned for one of the main virtues of it, which is merit, rewarding efficiency, improving labor division. So if it is less expensive not to discriminate, because this way we can expand the pan of potential employees, or perhaps a woman or an indigenous is better prepared for a job, why then don't we defend anti-discrimination law and we promote it as a tool of social policy, just as the Zeppelin neo-structuralism did during the 90s? The idea of social inclusion of anti-discrimination law that will enable us to have a social cohesion as countries capable of growing our competitive advantages in a global economy seems to be a good antidote, low cost, that can be easily implemented and make us believe that somehow we have already complied with our program of progressive policies. Even worse, how can we understand the boom of anti-discrimination policies in Latin America, a region which has not received much from the state and well-being, and only in the last decade, in the other boom, the commodities, it started thinking on more universal social policies. So in depth, this is an attempt to rescue the progressist nature of anti-discrimination law. Therefore, in the context of Latin America, what is the position of anti-discrimination law with the tools we have at hand in a theory of social emancipation that will take care of the challenges of the Latin American societies? In the discussion of the dominant Anglo-Saxon political discussion that comes up after Rawls made its publication, anti-discrimination law seems to move between two different concepts of equality, one which is relational and one is distributive. Although in principle, it seems to be more concerned from the quality of status, that my condition as a homosexual be respected and my status be accepted in public life. Anti-discrimination law is at the same time a central part of the basic structure, in the extent that it also is based on access to goods or assets or benefits. It represents a factor in a redistributive policy. Anti-discrimination law then seems to be a panacea. It improves social relationships. It respects diversity, that the public companies and enterprises are full of women, of disabled persons, with social minorities, but it also solves problems on the fair distribution of the resources that determine our material well-being. So the government of all the political directions are thinking that they are solving two things at the same time. I don't know if you can use this analogy here. But in spite of this, there are reactions to this consensus of all the governments, all the different political orientations. There is some type of backlash, like from the conservatives that believe that anti-discrimination law is an intervention of domains reserved for families or the church, or the libertarians that believe that anti-discrimination law is against the freedom of contracting, or part of the left wing that sees the anti-discrimination law like the human face of neoliberalism. As Alexander Samig would say, anti-discriminatory law is the lady of neoliberalism. And then in this context, I repeat the question that invited me to do this work. How can we explain anti-discrimination law in Latin America, its practice and its promises? And before developing the basis of what I consider could be an appropriate anti-discrimination law for our region, I believe it is important to make a brief theoretical parenthesis. And I want to do it so we can all be aware of the promises and it can fulfill, or those that cannot be fulfilled by this anti-discrimination law. And based on the concept of Nancy Fraser, we believe that anti-discrimination law is not a panacea, one solution for all the problems in all the areas, in all the spheres, economic, social, cultural, but it can be understood mostly as a mechanism to fight the lack of recognition, basically injustices which origin goes back to culture, basically. And the theory of recognition by Nancy Fraser, which is a theory of recognition as a status, emphasizes that what is important are the institutionalized patterns of value that subordinate certain persons just for the mere fact of belonging to certain groups, eroding their capacity of participating as peers in social life. At the beginning of her work, she talked about the reformative areas that would transform all these patterns that, together with redistributive policies, ended up in just applying stereotypes into indigenous women, for example, or single mothers as like those living out of social assistance. She preferred to consider the patterns from which distinctions were made. She was in favor for a socialism for redistribution and deconstructionism for recognition. However, later on, she changed her approach, and sometimes she says we need to choose the remedies according to our struggles, our circumstances, our context within which we fight, just like some policies that seems to be only affirmative but not transformative in order to rebuild identities, but they seem to be necessary as a first step for the transformation of cultural patterns. And here I quote the performance of indigenous peoples or the movement of settlers in Vías Miseria, Argentina, who confirm their identity as villeros because they use the tools of anti-discrimination law. Fraser's dilemma then is not between recognition or the redistribution of a famous book of Axel Connell, but a practical and strategic remedy between the remedies we use to fight against certain injustice, which origins can be brought down to one of the domains, but they are based on mutual influences, like such as economics and politics. And this is important to understand the limits of the transforming capacity that the discrimination law can have and position it in a more wider idea of social emancipation and have a better use of all of our capabilities, not to mobilize law only, but our position to protest or demonstrate that our indignation be shown. What does it mean that the damages occur in culture that anti-discrimination law is dedicated to fight against injustices coming from culture. What does this mean in Fraser's theory versus Judith Bartlett? Nancy Fraser thinks we need to avoid coupling what is cultural with the symbolic and economic with material. Therefore, the lack of recognition and its different manifestations are so material as economic damages. They are involved materially, represented in certain patterns, formal or informal. Versus Butler, who reduces everything to the sexual division of labor, Fraser looks for spaces where capitalism doesn't need heterosexism. Fighting against heterosexism is not always fighting against capitalism. As many times anti-discrimination law has shown to us, this can be used as an instrument to radicalize market positions, as a device to modify issues that should be outside the profitable, like several Argentinian cases show with respect to the discrimination made by public services against the emergency areas or red areas of Buenos Aires, areas which the telecommunication services deny the services because they are dangerous, because the wires will be stolen, etc. But what happens if the damages occur in the cultural setting? This can have effects in the other one. What Fraser says is the concept of interimbrication. And it is evident that in all domains, economic, the political, and the cultural are related, but this does not mean that the remedies should be approached the three areas at the same level. And the discrimination law then is not a low-cost panacea as Latin American governments seem to think, who have enacted anti-discrimination laws recently, thinking that this way they can get aside of all the policies, but rather it should be integrated in a theory of a broader emancipation, and its role can be theoretically clear of what it can comply with and what it cannot comply with. Considering what I've said so far, what are the bases for Latin American anti-discrimination law that can really explain its transformative nature in a context marked by a deep social disintegration, that the Latin American social fabric is more disintegrated and there is a growing integration of market? Then the cohesion occurs after market integration and not from this social fabric that has brought us together. So I will develop now four bases. The first comes from the context, and we've already heard something about this from Francisca, an anti-discrimination law that operates in the social economic context that it cannot be left aside, marked by poverty and inequality. So the question is, how is anti-discrimination law affected, how it is accepted by the social realities in Latin America when 1 out of every 3 inhabitants, or even more, if we consider the people who are rather at the age, who are in the about to fall into the line of poverty. So 1 out of every 3 poor inhabitants, or half of them, are in actual condition of vulnerability, and it is characterized according to the Gini index. So how is this context affecting anti-discrimination law? Chisca said during her presentation that intersectionality, Latin America has a face of the poor. That's the face we see, at least. So on the one hand, it is evident that poor people are overrepresented in the different groups determined by the areas protected by anti-discrimination law. I won't delve into this. Statistics say it. But on the other hand, it is evident that poor people suffer damages and injustices equivalent to other groups protected by anti-discrimination law, such as lack of recognition, social exclusion, or the lack of political consideration. Besides, and perhaps confirming a tendency of other studies of public opinion about the experience in anti-discrimination, considering all the large polls on discrimination in Mexico, Chile, Colombia, and Argentina, the different anti-discrimination statutes in Latin America have included poverty, class, income, or the socioeconomic position as protected categories. And in the case of inequality, we still need to see the capacity for non-discrimination law to question certain arrangements, but the constitutional case of the Colombian constitution, in the case of budget reductions after certain economic crisis, can be a good starting point. Equality and non-discrimination can be used as a procedural element that in times of crisis will enable us to accentuate on those who can really help versus those who need most help. Just as Sarah Warren says, in Latin America, a big dilemma between the redistribution that affects so many people. The North doesn't have such a depth in Latin America. Perhaps it is obvious from the scenario of this newly created law is acting. Many of those who are discriminated tend to be poor, so the communication between the redistribution and recognition and representation seem to be obvious. And although it's true that anti-discrimination law can sometimes used as a market instrument to open up the doors of the society to the market where they are known, like in the case of Argentina, for example, there is a positive trend to use it to question the cultural conditions that end up reproducing poverty. For example, anti-discrimination law can be used and has been used to question emergency social policies, like in the cases of the container schools in Argentina after the crisis of 2000, where they use anti-discrimination law to question a policy of social assistance. That's really interesting. Or questioning the stigmatizing effects that some social policies would have, especially in the reproduction of the cultural prejudice against poverty and anti-discrimination law that is in charge of this discrimination can be used to find conditional social policies into non-conditional, more universal policies, like in the case of women in Mexico who have acted against Progresa, or in Argentina, the cases that exist against the Universal Family Assignment, AUF. So in this first element, anti-discrimination law is fundamental in the context of newly emerging or incipient well-being states, so we can avoid the mistakes of the well-being status in Europe, based on the belief that they were homogeneous societies where the man was the main supporter of the home without approaching problems like the ones we have today, such as migrants, refugees, and other groups. A second basis defends the need to base anti-discrimination law in substantial equality that shows the importance that equality has in all its dimensions in a legal order. In principle, it is considered an alternative to other conceptions that want to visibilize the importance that it has for the labor market or development market. The case of European non-discrimination law or the anti-discrimination law in the UK are evidence of this, that the first time we had a European notion of the idea of equality and non-discrimination was after the analysis of comparative advantages were made of those countries that respected anti-discrimination rules when they joined a common market. The typical claim of France against the European community because of the French law of equal payment for the equal type of job. At the same time, the first time we heard about emerging this anti-discrimination law was in the British labor law handbooks related with job offers, or speaking about discrimination as variables of unfair dismissal. And although the British, as European and discrimination law today want to treat equality as a fundamental right or a larger principle, it still subsists with a historical dependence of its origins. According to Nicholas Bamford, the idea that anti-discrimination law pertains to an area that is limited of law, and it doesn't have to do at the level of constitutional order, it still acts as a constitutional principle that has an impact in every context, public and private and state-owned versus private. In Latin America, I distinguish something different and promissory, different contributions or contributional reforms of the third wave that moved to concepts of substantive equality and contracts which not change their movements towards case law permitted to elaborate different areas that will assume this new understanding of equality. And although the emergence of these constitutional anti-discrimination principles at the beginning of the 90s occurred simultaneously to the regulation, privatization, processes influenced by Washington, like in the case of Menem, the role of social movements and legal mobilization strategies, I believe, have been crucial to reset this apparent comparability or compatibility between anti-discrimination law on the one hand and neoliberalism on the other. And this is an impact, social movements and legal mobilization have moved forward to such a point that were not highlighted by law, especially with respect to access to certain basic assets that were not guaranteed by the constitutional order. Thus, I say that the Latin American constitutional order, whether because of the impact of the legal mobilization strategies or the mobilization of human rights, has made us better support, like common core that Chisca mentioned. And if we look at the constitutional scenario, there is certain consensus that constitutional clauses demand something more than the mere protection of equality before the law. A third basis, and I will finish soon. How much time do I have left? You have time to close. Fine. A third basis then assumes that it's an anti-discrimination law that takes force in a crisis of neo-constitutionalism marked by the need of endowing of legitimacy of different processes that would create a real and effective reality, paraphrasing Article 13 of the Constitution of Argentina. And one of the evidence was what Roberto Bargarella had called the defeat of law in Latin America, has been the permanent frustration of the normative promises from legislative bodies that seem to be promising, but once they are enacted, they are just protecting their followers. Not even the most promissory victories of Latin American neoliberalism has been able to consolidate processes that will maintain social changes and are sustainable with time. So in other words, Latin American neo-constitutionalism, assuming the incapacity of political processes and neglecting these ones, of assuming structural problems that affect the entire region, ended up in the voice of the judges that little they could do to comply with this and to have a reality of this process. The recent administrative evasion of anti-discrimination law in some countries in Latin America, especially because of the impact and protagonism of the National Institution of Human Rights, the defense departments of the people who have been slowly growing, has been a good basis to have a more focalized anti-discrimination law to make their promises true instead of growing organically. And a fourth basis, and the last one, and with this I finish, and perhaps the one that needs more development is the existence of the development of anti-discrimination statutes that will prevent the fragmentation or the hierarchy of groups that are seen in some comparative regimes. Some are considering that the need of this is an obligation, an international obligation resulting from international human rights agreements. The need of developing general statutes would also end up in having a doctrine as well as practical element. Doctrine because it is necessary to explain all the forms of discrimination that are intentional or focalized, systemic, simple, or multiple, because it explains that all the ways of discrimination are just as reproachable. Even more, we can start distinguishing levels of guilt with respect to penalties of monetary compensations, or if we can find solutions or more collective repairs before than being focused on one single responsible party, but also from a practical need, because having unique statutes that will allow all the victims to resort to a series of laws that can only increase the competence of the victims for more institutional care, which is a negative competence, and will end up periodically irritating those who are against particular causes, causing special particular wars that prevent us from seeing problems in a comprehensive manner. So preventing what George Ruthergen, from a very conservative perspective in the USA, has called a disgregate discrimination that recognizes different statutes and regimes according to the different ways of discrimination, and depending on the social groups involved, different types of judicial scrutiny or different types of remedies according to the category that is protected. The recent trend in Latin America is to follow Europe in this direction, and this is also a promissory basis, as shown in the recent proposals to amendments to the anti-discrimination law in Argentina, in Paraguay, in Mexico, and Bolivia. And I want to finish with a brief reflection, and with this I finish. How much we have moved forward in anti-discrimination law in Latin America can be considered an original mark, not because of the Latin American obsession of creating something new to the rest of the world, such as the European world or the American world, but in order to adjust to our context, a project that promises to improve the life of those who have suffered, not only because of the prevailing cultural patterns that prevent women or people with disabilities to have participation, but because of the permanent frustration they have suffered over the successive reforms, so-called progressist. And this project must be framed within a larger theory of social emancipation, where each one of the legal tools will occupy their position, being adjusted to injustices as well as the different forms of repair. And with this, I finish my presentation.
Thank you, Alberto.
We have receiving different questions, but we will ask them by the end. That Dr. Clérico will be next.
Thank you. I'm going to share my screen. Well, first and foremost, I'd like to thank the Constitutional Studies Center for organizing these events. You've been, well, they are very accessible for the audience. You have this open spirit, and thank you for the invitation. And I think also, I don't know if, well, yes, I'd like to thank you for being in this table with Chisca and with Alberto. And also I've learned a lot from your respective lectures. What I'm going to do is to pose some questions at two levels, the constitutional level and the inter-American level. And starting from what Chisca was saying, that common ground where several systems converge. At present, formulate some questions. The first part, the thesis that is formulated by Chisca clearly is the expansion of the equality approach. This is what she saw in that comparative analysis, that expansion of the equality approach is seen at the constitutional level in Latin America. And of course, this is reflected on the Inter-American Court of Human Rights and on the reports of the Inter-American Court of Human Rights. So I like to think about this spiral narrative, that is, those expansions of the approach take place. We talk about equality or inequality, they are spiral movements and they expand. Well, we can discuss the image of the spiral, but this is how I think about it. And we see that it was expanded with the inclusion of gender perspective, childhood, disabilities, elders, members of indigenous communities, Afro-descendants, displaced people, migrants, and in these three levels, the national, the inter-American, and the international levels. And in some constitutions of the region, the international instruments of human rights that refer to the prohibition of discrimination, equality, etc., have constitutional hierarchy, like the case of Argentina. And I'm going to ask a question to Alberto. The frame in many countries is broader. It's not only equality and not only anti-discriminatory law. In a case, I propose this because in the constitutional scope, the frame is more. It's not only equality or anti-discriminatory law. Of course, it is a law. In any case, it complements the constitutional scope. And if this is the case, and if we have this expansion of the equality approach, we should think about how this is reflected on three planes: the methodological plane, the material plane, and the remedial plane, and the guarantees of non-repetition. That is how these advances are seen in these three planes. For example, taking the case of Argentina, in the case, well, and this is very important, our works on equality, we shouldn't lose sight of the historical perspective, because the advances in equality, in any case, were not only from the 80s onwards, but we have a history of social constitutionalism. It was the beginning of the material equality, and we made this inequality visible in the relationship between employer and employee, and the need of including a collective subject for the negotiation of decent work conditions. The engine there was substantial equality or material equality. This goes hand in hand with the type of organization of society and the work relationship, and those people who were not part of this relationship had access to material or decent life conditions through the dependence of those people and the social systems that were generated to address social contingencies. In the 90s, there's an expansion of the equality paradigm because it will not depend on the work relationship anymore. The material equality paradigm will be for all the collectives, and constitutions of the region identify, and this is very interesting, beyond the reasons for which these constitutions were changed, there are diagnoses. That is, there are certain collectives that are not in a situation of equality for the effective use of rights, and therefore we have to do something to improve that position. This is incredible because this is in Article 75, Section 23 of the Argentinian Constitution, given the context explained by Alberto, the main reason of the constitutional reform of 94 was the constitutional re-election. However, in Article 75, Section 23, clearly there is a diagnosis of material inequality for the enjoyment of the rights of certain collectives, and we have to do something to achieve that equality. And this is expanded because some of the constitutions of the region, like the constitution in Argentina, recognizes most of the international human rights instruments referred to the review of discrimination, constitutional hierarchy, and also the CEDAW and the American Convention on Human Rights. So this expansion has a strong anchorage, a strong normative anchorage with constitutional hierarchy. Now, what I think, well, what I want to formulate is the difficulties we have when we apply these rules, the difficulties with respect to compartmentalization. That is, if Article 75, Section 23 says that there are certain collectives that are in unequal conditions for the enjoyment of rights, so we have to reinterpret, in quotation marks, all the discussions and doctrines about all the rights. Okay, because in the facts, there are certain collectives that are always left behind. So here I see a difficulty in terms of the development of any of the doctrines of rights. That is, the chapter of equality is aside, but that chapter of equality slowly knocks on the doors of the discussions in all the doctrine developments of the other rights, and even in positions that we could say are progressive. So in this lecture, I'd like to give you two examples. Why do we have this conception of material equality and this conception of expanded equality? Chisca and Alberto already said this. The context is the Latin American context of inequality, and this is one of the most unequal regions in the world, and this has a disproportionate effect. That is, it affects women, girls, and adolescents disproportionately under the frame of the feminization of poverty. So what's the effect? For example, also the Inter-American system, that is the Inter-American Court, have expanded the conception of equality, including these material conceptions of equality. So they expressly say they do not only work with a formal notion of equality, but they have advanced towards a concept of material or structural equality that stems from the recognition that certain sectors of the population require the adoption of affirmative measures of equality. And it has including an intersectional approach lately and a differential approach as well. And even, well, this approach has been in dialogue not only between the Inter-American Commission, if we see the productions of the Inter-American Commission and the Inter-American Court with the productions of the CEDAW and the Economic, Social, and Cultural Rights Commissions. And even though this is not well documented through the developments in the internal realm. So material equality is very broad because on one hand, it implies eliminating the direct and indirect discrimination, modify the cultural patterns, and eliminate gender stereotypes. This is fundamental. Identify the structural causes of inequality. What for? To improve the de facto position of women. But I think, as Chiska said, here we can include this same model can be used for other collectives in structural inequality to identify the causes to transform them. So this implied, as I said before, some methodological paths from legal, from the anti-discriminatory principle to, or adding structural inequality, adding the intersectional approach. And if we rebuild, for instance, the case law of the Inter-American Court of Human Rights, we are going to see we have the test of strict or narrow scrutiny when the norm evaluates based on sex and gender, putting in a disadvantageous position this group of people, like girls, women, and adolescents. And they added this test of structural inequality. That is the position of women, girls, and adolescents. These are isolated cases, but we have to see the social structure that puts them in states of subordination, domination, or oppression, and this is against of the enjoyment of rights. But also they saw how different factors are interrelated, putting women, girls, and adolescents, for instance, Afro-descendants, or women, girls, and adolescents who live in rural areas and are poor, they are in a special situation of structural disadvantage. So here, what Chiska was saying, we have this common floor that irradiates to all the regions. So here, I can stop in each one of these items. We see this in each one of these developments. We expanded the toolkit. From the methodological standpoint, today we have better tools to work with structural inequality, at least to identify structural inequality. How? Not only with facts, but also including the social context. And I'll go back to this in a moment. Besides, how this impacts the intensity of the restriction of rights and the social effects produced by that action, omission, or insufficiency. And now, the classical test of equality of scrutinies, we have the structural discrimination with an intersectional approach, and we develop the analysis of stereotypes. And in case law, we still use the situation of vulnerability. In remedial measures, these will have an effect on the remedial measure with a transformation vocation. And in that case, we have to see the non-repetition guarantees. That is, to what extent, if we identified the processes and structures that produce inequality, then the non-repetition guarantees, what could be the measure to tackle what's producing inequality for this not to happen again. This would be in terms of toolkit. And now, what is still a challenge is this: the problem of the compartmentalization. The equality approach is seen as something that is in a compartment. And I invite you to think about it or delve into this in the framework of a judgment. And as a challenge, I give you this report of the work group on arbitrary detention of the UN that analyzes 4 cases about arbitrary detention and criminalization of 4 Salvadorian women after an obstetric emergency. And in the specific case of Mrs. C. P, well, there was a complaint about an arbitrary arrest. Generally, women who are criminalized are young women who live in rural zones and they go to public hospitals for healthcare, and in cases of obstetric emergency, they end up being criminalized. But when the work group analyzed the case, what you can see in light green, well, the case of Mrs. CP and the other women who are imprisoned due to an obstetric emergency, there are structural problems in the exercise of fundamental rights. It's not only that they are arbitrarily detained. These women have a backpack that is full, that is a history of lack of access and enjoyment to several rights. Among others, equality in the access of healthcare services for people in a situation of vulnerability and discriminatory situations per se, like poverty. So this is a very interesting case. And this is the typical case of non-compartmentalization. That is, this is a case that doesn't use the equality test, but is part of the theory of the case. That is how I'm going to analyze this case. I have to analyze this case from structural inequality and arbitrary detention. And this is one link, among others, in the change of violations to the rights that these women suffer for being in structural inequality. In this case of structural inequality, it is intersected because it is gender, poverty, in many cases, rural women, and they often are young women. So this would be the first question and the first interest. That is, when we make, when we make comparative analysis about equality in the region, when we work with case law, we are missing this. We are losing sight in the analysis of how much the reception of the advances in material equality promote the case. That's the approach of the case. So we can see some light in this report, and I'm going to show you another one. I think this case is paradigmatic. This is the case of year 2020 of the Inter-American Court of Human Rights. Employees of Fábrica de Fuegos, Antonio de Jesus versus Brazil. In this case, the approach of the court, at least partially, the case is of structural inequality, and it's not as a compartment at the end of the judgment, but analyzing it in conjunction with the violation of a right. And This requires more elaboration. I don't have enough time. And this is the core of the case. I could say this would be my thesis. This is the approach of the case. In this case, this is about the explosion of a fireworks factory, and 60 women died, and some of them were, among others, girls. The court, well, they were employees of this factory of fireworks, and the court sentences Brazil for several reasons: the right of girls, boys, and adolescents, equality and non-discrimination, legal protection and legal guarantees, and ordered restitutions and non-repetition guarantees. They at least can be transformative. But what's important is here, when it evaluated the violations to the right to work in equitable and decent and satisfactory conditions of women, boys, girls, and adolescents who worked in that factory and exploded, they do that from an approach of structural inequality and intersectional. And I'm going to explain why this judgment. Well, this is what I said before, because it includes structural and intersectional discrimination, because discrimination due to economic position intersects with gender and Afro-descendants, and all this to evaluate the evaluation of the right to equitable and decent work conditions. But what called my attention from this case for good is this. And this is what should move us when we are analyzing in general cases and we have this context. We can't keep on working in a case with this context as if it weren't a case of structural inequality. That is, inequality that if inequality appears at the end of the case, it says something, because all the other I was evaluating, all the other violations to rights were evaluated as if they were violations, junctural violations, isolated violations, but they are neither junctural nor isolated, but they are links in the chain of structural violations, violations to the rights of these collectives that are in a disadvantageous position. Look at the context, and this is interesting. They include the analysis of the context. San Antonio de Jesus in Bahia is a city at the north of Brazil. This is the zone where Afro-descendant people live, and people who are Afro-descendants live in poverty. They work in the informal sector. They have no other means of work, and they can only work in factories. And this factory have never been controlled. So think about it. What does this factory produce? It produces fireworks. So what the context says is that Brazil is the second largest producer of fireworks. That is, the context puts, how to say that, puts at the core of gender inequality due to poverty, and Afro-descendants are at the core. That's why this is a paradigmatic case that I want to discuss with you, because the bodies of the people that due to their ethnicity and their economic and social situation and gender that are looked down, etc. This is not a coincidence that they can only have access to badly paid jobs, and they run the risk that their bodies might explode in the air. So look, in this case, deficit in the recognition with a strong impact on the access to economic and social goods, and then it has an impact on the real possibilities of participation of these collectives to file their complaints in the agenda. So we can see the characteristics of the victims: workers, women, girls, boys, Afro-descendants who are poor with low schooling. This is not a coincidence, because they don't have material conditions to exercise or to guarantee the enjoyment of the right to education. This has a strong impact on the real possibilities of having access to a decent job. And since those bodies are worthless, the state never controlled those factories, and that implied that it exploded and 60 women and girls died. So several legal actions started, and so far the judgment in the Inter-American Court of Human Rights, most of those cases are still open. So here you can see the importance, that is the access to justice of these women and girls is they don't have equal conditions for the access to justice, because more than 20 years have gone by and those cases are still open. So there's deficit in the recognition and an impact on the access to economic and social goods, and this has a strong impact on the real possibilities of participation in broad terms. And I interpret that justice for many collectives is one of the strategies to put their complaints in the agenda. So I'm talking about the evaluation to the right of equitable and satisfactory conditions that guarantee health, security, and work are coupled. So this is fundamental. The question is, what did the state do to take these women, gender, girls, gender, and age in situation of poverty and Afro-descendants to take them out of this structural discrimination situation? Because they had to accept a work that risked their lives and the integrity of their mind, of their children, because since there's no system of care, they took their children to work, and this is a chain. They also use labor of children or child labor, and in that chain, those boys and girls, or those girls, when they grew up, they would take their girls to work. So this is a very important chain, an interesting chain of inequality. So here the argumentation is on the state, and we reached the conclusion that the state didn't do anything from the point of view of the facts, because the situation was still the same, to improve the material conditions and life conditions of these women to have access to better jobs.
So if I go back to my first question, this one. So now we can see the broader approach of the inequality and structure from the same theory of the case, from where the entire case is approached, and not to leave it as a last chapter only in the end of the sentence that very little people read. And after all, if this is so, we have the image that the right to life, access to justice, the prevention of arbitrary arrest as not part of the inequalities. No, yes, of course. And this is precisely why they have higher probabilities of dying and they don't have access to the health system. They are criminalized. This is why their bodies fly up the air. This is why they don't have access to the world, labor, formal labor world that provides a dignified life. The second point I would like to present to you is this again. Great progress has been made in the focus of material equality. However, what we often see is that this is again in one part of the court ruling, and it doesn't move any other parts of the court ruling that are relevant. This is the case where we have three cases which are a paradigm. There are three elements of progress in the focus of material equality: Atala versus Chile. Case of paradigm on sexual orientation, Norinca versus Chile, people versus indigenous communities. And the last one, the women from Atenco, sexual torture versus Mexico. So most especially, we read again the case of Atala Rifo, sexual orientation discrimination. We can see that there are elements to have an analysis. First, because they include the concept of discrimination based on sexual orientation, even when it is not set forth in the Article 1.5 of the Convention of Human Rights. That was an important point forward. Then they say that sexual orientation cannot be used as a criteria to classify and distinguish between two groups with respect to the sexual orientation, and that the consequences of that classification will affect the rights of the LGBTI group. And an analysis of stereotype, and in repairs, we speak about these ones, but with transformative vocation, a leading case, definitely. And now, when we analyze the guarantee of impartiality, the tuition of the girls was removed from Mrs. Atala Rifo because Judge Atala Rifo, after she was divorced, she has started a relationship with a woman. So when her past spouse learned about this, they attacked the situation and they established a law, and the highest court of that country defined that the girls should go under the tuition of the father. So when we started analyzing the supposed reasons and arguments, we can see they are strongly based on stereotypes in the sexual orientation of Atala Rifo. So the Commission, as well as Atala Rifo, had requested the Inter-American Court to determine that the guarantee of impartiality had been infringed. Do you understand it? Because internally, if internally stereotypes were used, negative stereotypes based on the sexual orientation of persons, this means that what has happened? The persons that ruled were hand-tied. Why? Because they have been blindfolded. And this is where the point comes. Let us assume that the Inter-American Court in the field of equality had moved forward in the first part of Atala Rifo's ruling, speaking about structural equality, etc. It is really a strong argument, really interesting, but it is a step forward. So what can we expect when it analyzes the argumentative impartiality? And I will go from the legal operators who have removed the tuition of the girls based on sexual orientation stereotypes. Laura, I apologize for interrupting you. Just to tell you that we have 3 minutes left to close. Fine, I'll close soon. I'll finish soon. So I believe it is fundamental. If it was to do with personal impartiality, not the other sections. If in the first part of the ruling, the court said that there was structural inequality, that there had been based on gender stereotypes against the rights of the LGBTI group. The big question is, how is she going to distribute the burden of proof in terms of impartiality? Well, the burden of proof was still in the hands of the commission and the representation, rather the representatives of Mrs. Atala Rifo. So the big question is, this was the first part of the ruling, then structural impartiality. And then when they guarantee a personal impartiality, should they start from the assumption of partiality? Do you understand me? The question is basically, how can we see the expanded vision of material using the distribution of the proof in the area of guarantee of impartiality? I clearly believe that an expanded vision of material equality must revert the presumption of impartiality and start then by the partiality of the arguments. If at the first ruling you said it was a structural impartiality and the operators of the law used stereotypes types based on sexual orientation affecting the rights of Mrs. Sara Rifo, well, the one that has to make sure that was not a partiality situation is the state, because you can see it is very much separated, very much advanced in the merit in terms of discrimination. But when it needs to analyze a guarantee of impartiality, then it continues anchored in a vision of formal equality, we could call it. So this would be the second question. So we may continue reflecting on the fact of material equality must continue leading to the interpretation and the adjudication in law. Specifically, I consider the concept of rulings, but I can work with other areas, with legislative debates or decrees of the national executive. And I believe that with this, I will finish my presentation, and I thank you for your very kind attention. I hope so. Thank you so much. Thank you so much, Laura. Thank you, Alberto. Thank you, Chisca, for your wonderful presentations. First of all, we have lots of expressions of gratitude from all the people who are with us and lots of recognitions from Facebook and all the official sites of the court and the Center of Constitutional Studies. And we have a lot of questions. I wish we had more time, but I'll have to organize them in such a way that we can discuss them a little bit. What I would like to do is to ask to you two groups of questions, which I have grouped based on the topic, and we can open up the microphone so any of you can take the floor. First, a common topic on other questions has to do with the fact of paradigm developments of anti-discrimination law are based on an Anglo code. So one concern is how are we to import these developments to our Latin American problems, how to build our own law, which is what we heard from Alberto. And then some of the questions. First, do you think that considering the Latin American conditions, we need to fight distributive inequality? First, we have big problems in the region of recognition of dignity per status, but it seems that in our country, everything is involved with poverty. What mechanisms are better to mechanize these rights and reduce the inequality, considering the evident limitation of resources, the reasonability of public policies, the guarantee of essential nuclei, and finally, if poverty is the most latent injustice in our countries, how do we mark a line between social rights and the right against that discrimination in our social and normative context? This would be a first group of concerns or questions. And then the second one has to do briefly with the opposite. In the other direction, what could we expect from a Latin American anti-discrimination law, and how could it contribute to the developments in the USA and Europe? So you tell me which one do you prefer to discuss first, and any one of you who would like to take the floor, go ahead, please. Well, if you agree, I will start. Yes, indeed, the first question of the first cluster of groups is really interesting, and it has a lot to do with what Alberto said and things that Laura said as well. I wanted to react anyway, so I'm going to do it now. I find that this is a central debate. And yes, indeed, as Laura has said, we do have this tradition of equality and not of discrimination. And we also have the European thoughts that have reacted to the Anglo side of anti-discrimination law, making an analysis of continental roots of equality, which are also resounding in Latin America. So Alberto most probably will have a lot to say in this regard, but perhaps we in Latin America already have tools and already have a historical tradition, what Laura said, so as not to abandon this more holistic paradigm of equality, that somehow it is included also in the book by Val Braha, which is Anti-Discrimination Law in the jurisdictions of civil or continental law. I have not reflected a lot on this concept, but I believe we need to reflect on this, and that this more holistic development based on the idea of a more holistic equality, and perhaps much more connected to our historical traditions, and therefore with greater emphasis in redistribution that comes from our concept of social position could be very important. The second point I wanted to mention, it is really interesting to think, Laura, what you said, what the case you mentioned. Yes, in the investigation I've submitted, many female authors came to the conclusion that when the committees actually arrive to the intersectional, to the contextual, this is when they use the different ways of individual communications. That's precisely when they come to the problem from the case, something that they could do much better through individual communication system than through annual reports, etc. However, I don't know what you think. I believe that there is certain tension between the analysis power of detecting problems that is focused on the case and this element of causing holistic transformation of public policies. So as Latin American countries will be more focused on the case, will better identify the problems as you showed in the cases you mentioned. But at the same time, does this have cost or no in terms of larger messages, more transformational messages in some of the senses that Alberto mentioned that we are looking for specifically in a continent where transformation should be even more structural? And I believe that we'll only have the possibility, I don't know how we are going in time, but I wanted to have a third reaction very briefly to something that Alberto mentioned that I found very interesting. Yes, indeed, Europeans complain of deficit of inconstitutionalization, and they admire the power of the Latin American public law. And my intuition has always been to complain about the opposite. My intuition has been to complain about this inflation of regulations at the level of constitution and agreements, and means something that the Europeans have more, the French labor law, the Great Britain labor law that has permitted a great move forward. But I've always thought that exactly what we're missing, and somehow I mentioned it in my intervention, is to bring down the big regulatory messages that we have, that perhaps, yes, more developed than the European, and bring them down to labor law, administrative law, etc. And also what you said about the administrativization of the emergency Latin America, finally, of the non-discrimination ombudsman or the human rights national commissions, it's a very central point of debate, because I also tend to think in the past that, especially in Mexico, where there has been this emergence of equality units everywhere. So be careful of thinking that this can transform itself, or that this will transform the institutions where these equality units exist. However, recently, in the last years now, that the government of Mexico is removing the funding of different activities, now that this incipient administrativization is disappearing, now I think that perhaps they weren't that useless. So anyway, I didn't draw many conclusions, but things that I find really interesting to analyze vis-a-vis to this concept, to define what is what we should try to promote, so as anti-discrimination law is more of ours and be much more transformative. And the direction you pointed, well, I've already mentioned all my points in case we need to close. If we allow me to react to something what Chisca said, when I was speaking about the theory of case, I did not speak about the case concretely, rather on the contrary. When I say that if we consider the context, and be careful when I speak about context, I mean social context, and not taking into account whether the woman live, the situation of poverty, etc. That oftentimes this gives you an idea and allow you to identify that this is not an isolated case that responds to a pattern of discrimination. So the point is, even when you are working on a case, from the beginning, it should be set forth as a structural problem. Is this clear? Yes, you are absolutely right. Yes, it's not to close this case, but to make it larger, because otherwise we will have similar cases that will respond to the same pattern. So you think the way you say, then when you go to the last part of the ruling, of course, the remedy should tackle this pattern of inequality or discrimination. And with respect to the last point, this is why I was saying and how it is framed. I prefer to speak about egalitarian constitutionalism or inequality. I believe that the development of anti-discrimination law is one case, not judicially speaking, but it is one link in a larger framework. And there we can recover the developments of each one of the countries of the region and the region in general, because not that we have had labor elements which were attacked by the policies of labor flexibilization. So it doesn't mean that they have very strong labor laws over there and we do not have them. Labor laws in Argentina were the engine for the Constitution of 1949. It was later on canceled, but this is still the origin of the article that is still in force, 14Bs, which labor laws is a level and you cannot undermine them. And this was strongly attacked through the policies of the 90s of the neoliberals, and it is still the discussion today. This is something that is constantly attacked, and this is why I say that the case of Mujeres de Fuego, Antonio de Jesus, that's the case, fire women, because the state is leaving the area for these bodies to be exploited. When you read the case, you will see that there is labor laws, that there is regulation of those jobs that are highly at risk. But what happened? This factory was never controlled. So the failure, among other things, is the power of the job police, labor administration, labor management that is in charge of controlling the dignified conditions of control. So this is again part of a package of quote unquote labor, de facto labor flexibilization. So I believe that if we don't find that the structural has to do with factors that stop with the labor laws, if these are laws that are actually protecting the jobs or they keep on looking for flexibilization, etc., then there is a strong tradition in Latin America in this regard, but there is also a strong tradition of removing these in the days of the 90s.
Well, I was saying that you're right, but things we've been seeing with Sophia and the contrast of Mexican constitutional case law, family law versus labor law. And it's impressive how the court has decreased the criterion to family law, and they are not reducing it to labor law. It's true that this is the result of certain historical conquests. It is true that several dimensions, especially after the neoliberal movement of the 90s, it needs that. So you're right, but I think I was thinking about the case of Mexico, the asymmetries of the constitutionalization of the different spheres. And for me, the difficulties in the constitutionalization of the labor aspects and the transformation thereof has not started. It started in family law, in the private redistribution, alimony, etc. That's why I was saying that. And in Argentina, it's different. No, yes. I'm talking about historical aspects, but also the question, it's not a coincidence that in labor, this is the case. And it also happens in family law. Thank you. Alberto, you have the floor to wrap up. Very well. So how can we import the Anglo paradigm? This is a very good question. I think that in Latin America, assuming this paradigm of equality, this holistic paradigm that gives rights to build on that, we can use what has been advanced in other times. Remember that the federal law on civil rights in the US, for the first one, incorporated a concept of disproportionate impact in the 60s. In the US, the British anti-discriminatory law was developed in the 50s, like the first directives. So the question that we have to ask is how we can use the time that has gone by in other jurisdictions and that has allowed them to build very sophisticated schemes. In the case of Europe, reaching a guideline of the European Union that obliges the member states to design equality bodies with certain institutional requirements. So that's the level of sophistication or guidelines that, or the law of the European Union that is directly applicable in the member states. When you see the progress of the equal employment opportunities condition in the US, for example, to review if there's a suspicion of indirect discrimination, they have this rule of thumb, this rule of 80-20. That's the degree of sophistication. So when we see and we face this comparative outlook in Latin America, we say, wow, let's use what they have done well and avoid what they have done wrongly. So this idea of generating this compartmentalization, as Laura said, and generate a different regime for disabled people, a different regime for people discriminated due to pregnancy. So it's important to produce institutional modulations, but if you lose this holistic side that all forms of discrimination, either direct, indirect, denial of reasonable adjustments, sexual violence as discrimination, they are all injustices, sorry, that come from the same injustice. Why people have to consider these categories, these criteria, these conditions as impediments to be equal before others. And I think that we have to avoid the US problem. This is being a problem now. When I see, for instance, the evaluation of the bona fide quality exception, when I studied that in the US, there are different regimens for women and for the color of your skin, and that's crazy. Having different legal scrutiny types to discriminate by race or color is crazy. So this exacerbates cultural wars, is the worst version of the identity policies that gives rise to this campist backlash. Victims, social groups competing for more protection in the San Antonio district with that judgment where poverty is left out of the categories. Class, poverty, socioeconomic status is out of the North American law of anti-discrimination. If you see Europe, beyond that, the equality guidelines do not consider poverty or socioeconomic status. What we see is a trend. If you see the national laws, the French, Swedish laws, most of the European jurisdictions are considering class, poverty, property, income, the socioeconomic status as protected categories. And this goes with the rationale of some recent judgments of the European Court of Human Rights. So I think we have to copy good things and not bad things. That would be my pragmatic recipe to incorporate the Anglo paradigm. Now, with respect to that, also say that the theoretical reflection, something recent, seeing that non-discrimination was never a concern for liberals. For the discussion of the political philosophy from Roberts, discrimination was seen as a specific problem. It was an intentionally wrong act against others, but this didn't have to be evaluated from the basic structure of society. So even though they have many years of reflection on legal practice, there's little philosophical reflection to generate a more consistent Latin American law on anti-discrimination. Now, how can we fight distributive injustice, and what are the mechanisms that can be used? So this is the call I was making. We can't wait that the anti-discriminatory law does everything. I'm seeing the modification to the Chilean anti-discrimination law that incorporates structural discrimination as a specific form of discrimination. Of course, the question is, if we really address indirect or structural discrimination, basically, let's abandon social rights as a discourse and let's focus on anti-discrimination law. And that's not the way. I think trying to generate a theoretical reflection that puts anti-discrimination law in its place and incorporates it into a broader theory of the relationship between law and social right, as Chisca invited us to do in the beginning. And the dividing line between social rights and anti-discrimination law can be shaped very interestingly. This is very polemic, but I'm not a fan of the justiciability of social rights in Latin America. I think that the celebratory tone with which we have received the last judgments of the Inter-American Court interpreting Article 26 as recognizing a catalog of social rights, I think loses sight of the rich jurisprudence that the Inter-American Court had, especially in the case of indigenous peoples and girls, boys, and adolescents, where social rights served at the light of what Laura showed us as an approach to say, look, a situation of structural inequality impedes people to be recognized as equal in a community. So that jurisprudence was richer because social rights are not like civil rights. Social rights do not point to individual interests. Social rights point to collective dimensions according to each one's needs. This is what Marx said, but also the Inter-American Court in its case law. And I think that losing sight of that by focusing, the amount of institutional resources of the Inter-American Court to try to find the direct justiciability of social rights in Article 26 has made to lose sight of the progress it made of understanding social rights as a lens to see especially how effective, if in practice, civil rights are enjoyed in an equal and non-discriminatory plane. So what I was inviting you is, I think, well, with that, I would answer the second question. Well, definitely, Kiska's phrase was great in the beginning. You see the books on the theory of intersectionality or multiple discrimination in Europe, and you see this in Latin America, and it's the face of intersectionality in Latin America is poverty, or the main face. It has multiple faces, but I would say that poverty is quite powerful. And that's why in the indirect discrimination judgments that I have analyzed, and I've collected several ones, the judgments, the legal rationale is obvious. Is like this Jacobelli versus Ohio test. A judge had to decide what was pornography and what was freedom of speech. And this judge said, well, I know it when I see it. I recognize it immediately when I see it. And the courts in Latin America, when they have judged intersectionality cases that include poverty, we don't have to produce a regression like statistics or these econometric studies to prove indirect discrimination. For example, that you see in the US or that you see in Europe, because it's not necessary. It's evident that in Latin America, poverty and the linkage between the recognition and the redistribution that in Europe is seen as a tragic dilemma, things that are separate. Now in Latin America, it's like we've been dealing with this for 200 years, and we keep on having this problem with the debt that we have. And I think trying to see the multiple faces of poverty is the big challenge that should be faced by the anti-discriminatory law in Latin America. So the zeal they have in Europe for this anti-discrimination law to move towards that path. Section 49 that has not been implemented, the fear of the successive conservative governments in UK to implement this aspect of the Equality Act of 2010 has to do with that, with opening the doors, or that between the protected categories by the equality guidance, they do not include the socioeconomic status or poverty. That speaks of the fear in Europe. Either I'm open the comportments of the anti-discrimination law to evaluate the socioeconomic status. I think that in Latin America we have that. And when you check the surveys, just to mention 3 surveys, the Mexican, the Chilean, and the Argentinian, these are general surveys of bodies, el INADE in Argentina, the Human Rights Commission in Mexico, and the Human Rights Institution in Chile. So what's the protected category, or why you have felt more discriminated? Many of them mention poverty, their clothes. For us, what's obvious is something that in Europe is seen differently. I think that's our lesson, or the possibility of this obsession with literature, the Latin American movies, that it's not the copy or the mausoleum of modernities, as Alan Ingen said, Paul Wykin, this Latin American historian. Latin America is the mausoleum of projects that do not succeed in Europe. I think we can do something differently to show something original that is not a bad copy. Thank you, Laura, Alberto, Chisca. Thank you very, very much. May I say something else? Can we keep on discussing this in another conference about the direct justiciability of social rights? I think this is justified, Because if we see case law in this regard, it's not that all the developments that had occurred in other parts of the articles. And maybe my thesis would be that we can earn something. I don't know what would have happened in this case of employees of San Antonio de Jesus versus Brazil only by Connexity. If it had had the same wealth with the development of Article 26, these are cases about the access to the right to work. For millions of people, they live discrimination due to class, poverty, ethnicity, and gender. So I think this is a pending discussion. Thank you very much, Laura. I'm sorry, literally the broadcast will be finished. I thank you, Chisca and Alberto, for your participations, and I also thank all the people who were with us in this table of comparative developments of anti-discriminatory law in Latin America of the International Congress on Constitutional Law. And we also invite you to the edition 19 of the International Fair of Legal Books of the Judiciary that will take place from November 8 to 12. The fair will have 2 video rooms. One of them will showcase 13 legal works and several cultural events. And we will have personalities like Mark Tushner, Roberto Gargarella, Isabel Cristina Jaramillo, Daniel Vasquez, Ana Magaloni, among others. And in the other video room, we will have children activities, conferences, and roundtables. Do not miss the International Book Fair. This is a great event. You can subscribe to it. You can visit our website. It's virtual.feria del libro, and we will issue a certificate for you. Have an excellent day. Thank you. Thank you. Greetings.